All right, a very good afternoon, ladies and gentlemen, wherever you are joining us from. It's sunny day here in Arusha, Tanzania, and I hope you're having a good day wherever you are catching us from. My name is Gabriel Achaye, and I speak to you from the East Africa Law Society Secretariat. This afternoon, we are excited because it's a session that we have been looking forward to. Are quite enthusiastic about this because of the importance of the subject. And this afternoon we are discussing a very pertinent yet very critical a topic that most of us who are joining this call are quite enthusiastic about, and that is in particular mastering litigation at the East Africa Court of Justice. And today we'll be speaking strategies, procedures, and opportunities for legal practitioners. And to take us through this session is none other than our dear moderator, a lady who was called to the bar in 2014, which means she has over 10 years practice experience. She's managing partner and head of commercial and project finance of Mesa Advocates, but also she's a legal consultant with World Bank Legal Presidency. She holds a Master of Laws in International Business and Economic Law from Georgetown University Law Center, Washington, D.C., a diploma in legal practice from Law Development Center, Bachelor of Laws degree from alma mater, Makerere University. And she's a chartered mediator certificate from MTEA, and a certificate in legal tech and digital transformation of law. Talk about being a woman of many talents. And I'll show you Mebo Kisaka Mutungi, our esteemed moderator for this afternoon, but also importantly, she serves as our chairperson of our International Trade and Regional Integration Committee. Karibu sana Mebo, you have us for the next 2 hours, and we are all yours, and we're excited to hear from you and all our panelists. Karibu.
Thank you very much. Thank you very much, Gabriel. And as Gabriel has rightly put it, today we are mastering litigation at the East African Court of Justice. It's very exciting because you'll get to know the strategies, procedures, and opportunities for lawyers. So, as a background, the East African Court of Justice plays a pivotal role in ensuring the rule of law, interpreting the East African Community Treaty, the safeguarding regional and the safeguarding of regional integration efforts. As the region deepens its economic, political, and legal integration, the court has become a critical forum for resolving disputes involving member states, regional institutions, and private parties. For legal practitioners in our region, East Africa, litigation before the EACJ presents both unique opportunities and complex procedural challenges. So as lawyers, we must navigate regional legal frameworks, procedural rules, and strategic considerations that differ significantly from our national courts. Mastery of these procedures is essential not only for effective presentation, but also for contributing to the development of regional jurisprudence and integration law. And I'm very happy that we have over 80 participants today to just join us today to learn the strategies, procedures, and opportunities for lawyers. So this webinar will equip you with comprehensive understanding of the EACJ litigation, covering procedure rules, case management strategies, and practical guidance on maximizing legal outcomes from various cases under the EACJ. Participants will gain insights and from our very capable panelists who have been appearing before the court. And with these insights, you'll be able to advise your clients effectively, handle cross-border disputes, and leverage opportunities emerging from the court's expanding jurisdiction. So therefore, ladies and gentlemen, I would like to introduce our our participants, and it's my pleasure to introduce to you distinguished speakers and partners who are also accomplished practicing lawyers who bring with them a wealth of experience in regional and international litigation. They have appeared before courts and tribunals at both national and regional levels and have guided clients through some of the most complex disputes in areas ranging from commercial law to human rights, treaty interpretation, and to cross-border trade. And most importantly, we have our keynote speaker, who is His Worship Eupnalis Okubo. Eupnalis Okubo is the former registrar of the East African Court of Justice, and we are very privileged to have him to just give us the insights on navigating the EACJ. Who better to give you insights on navigating the EACJ than the former registrar of the EACJ? So our keynote speaker will take us through unlocking procedural excellence and jurisdictional clarity for effective litigation. He will provide us with an authoritative overview of the EACJ structure, divisions, and jurisdictional mandate. He will clarify for us key procedure rules, filing requirements, and best practices for compliance. And lastly, he will offer strategic insights for initiating and responding to cases to maximize legal outcomes. So ladies and gentlemen, you are in the right place. And I'm very excited that we have over 100 attendees today. So Your Worship, Mr. Eupnalis Okubo, we have over 100 attendees, very excited to hear and learn from you. And without further ado, I thereby introduce our speaker, His Worship Eupnalis Okubo.
Thank you very much, Mabel. And that number is quite encouraging. I will have a short presentation because I think for you to master litigation at EACJ, you also need to understand that court. Let me just try to share my screen. Are you able to see it?
Yes, Your Worship.
Okay. Now, of course, these are the mission and mission. These are things some of you know. The core values of the court, this is common in most jurisdictions. That is what some of you know. This is just briefly what I'll go into. Then once I finish with the challenges, I'll look at the strategies now of how one can successfully practice at the East African Court of Justice. Some of you may be new, or it is the first time you're attending such a presentation, but you still want to understand what is this court, East African Community. Now, the community is established by a treaty, and Article 9 sets up the court as an organ of the community, which is a judicial body. Just like any other government with 3 arms of government, the community is a big country. Therefore, it also has a parliament, it has executive, and it has a court. The mandate of this court is purely peaceful resolution of disputes in the region as far as the violation of the treaty is concerned. So don't come to that court. You want to solve a dispute which does not involve violation of the treaty, unless it is a matter that is for arbitration, and where your arbitration clause confers that authority to the court. So the court was set up in 2021, inaugurated in 2021, but it took 5 years before it got its first case, in the case of Callistus Mwatela. It has 2 divisions, all of them sit in Arusha, but we introduced a rotational court before I left the court, where every year the court at least sits in a country. We have sat in Tanzania, of course, we have sat in Dar es Salaam, besides the normal seat in Arusha. We have sat in Bujumbura, we have sat in Kigali this year. Last year, I think it was Uganda. this year it may be Kenya. The first instance division has 5 judges, but it has capacity for 10, so there are 5 who are missing. The appellate division has a maximum of 5 judges, so the appellate division is full. And that is why the total number of judges as prescribed in the treaty is 15. They are all appointed by the summit on recommendation of a partner state. That is what the treaty says. Of course, Kenyan court has gone further that you don't just appoint, some process must be there before that person can be appointed. And once appointed, this judge will serve for a maximum of 7 years, or if he gets to age 70. Unfortunately, we lost quite very good judges who are retiring at 70, but they had not even stayed in the court for 7 years. Just like most judiciaries, also these judges can be removed by an ad hoc independent tribunal, and the whole staff and the whole machinery is run by the registrar. Now, these are the current judges of the courts. We have the president, the vice president, and then the 3 judges of the court of the appellate division. Then you have the principal judge and the deputy principal judge, and then 3 judges in the first instance division. Kenya has not appointed a judge. The one who was there left, Kenya is yet to replace. South Sudan has not appointed a replacement of the judge who was there. Otherwise, then there will have been 7. Somalia, who is the latest entrant in the community, I'm sure they've been working on nominating somebody to come and be a judge. And if that happens, then the first instance division will have a total of 80 judges, which to me, that will be encouraging, so that at least you can have 2 panels of 3 judges sitting concurrently instead of the current practice where you get only 1 panel. Now, the first instance division jurisdiction is stated in Article 27, which is interpretation and application of the treaty. And also, under Article 31, it provides where the community staff can also ventilate where they feel there's a problem with their contract of employment. So this is where the employees of the community can sue EAC in the courts. Then on the appellate division, this is an appeal. So you only go there on 3 grounds only: point of law, lack of jurisdiction, and procedural irregularity. No facts there. It is also the appellate division that can issue an advisory opinion under Article 36 for obvious reasons. An advisory opinion is binding and it must be final. So we cannot have the first instance division issuing an advisory opinion, then the appellate may be issuing another advisory opinion contrary to what was issued in the first instance division. And it also deals with what is called preliminary rulings from national courts. I'll be talking about this later. Then I've put arbitration there, which cuts across, because what happens if you've given this court jurisdiction to handle your arbitration matters, a panel of arbitrators will be selected, and there could be some of them could be from the first instance division, others could be from the appellate division. Of course, the only problem here is that the arbitrators will be the very judges of that court. There was now who will form a panel that will hear the arbitration. Now, one good thing with these courts, which you all need to appreciate, is you don't need to exhaust local remedies. You cannot walk to COMESA court if you had not exhausted local remedies. So just look, by the time you are getting to the COMESA court, you have spent maybe 10 years in courts, if you are lucky, or more, because COMESA court will tell you, no, go and exhaust local remedies before you come here. The other good thing to note about this case is that we abolished filing fees. You don't need filing fees. You just walk there, file your papers. And we did, one of the reasons that why we did this is because Article 7 says the treaty will be people-centered and market-driven. So you cannot say it is people-centered. At the same time, you are making it difficult for the citizens to access the facilities of the court. So we did away with that. Initially, when we thought of removing filing fees, there was fear that there'll be a floodgate of cases. Anybody who is idle was going to file a case there. But we didn't see that happening. We get very interesting cases and real cases touching on interpretation of the treaty. Article 27(2) prescribes the jurisdiction of the court: original, appellate, human rights, and other jurisdiction as may be conferred by the Council of Ministers through a protocol of extended jurisdiction of the court. Of course, this has brought a problem. At some point, we were really pushing to have the jurisdiction of the court extended through a protocol, but that was never done because the ministers felt they are going to be giving the court too much powers. One of the major issues that has been discussed and discussed and discussed, and a lot has been written about it, is whether the court has jurisdiction on human rights. But of course, the court did not answer that question directly. However, it somehow got a way to go around it and conferred itself jurisdiction to hear matters of human rights, so long as those matters of human rights are also alleging violation of the treaty. That was the first case in the Katabazi case. It never stopped there. After that, 90% of the cases filed in EAC touch on human rights. And of course, that decision was followed with quite a number of cases successfully, including the medical legal unit case, and even the Tenda Sebalu case touched on that, although what it raised mainly was that the partner states had taken a long time to make comments on conferring appellate jurisdiction to EACJ on matters arising from national court. So of course, you can understand the fear of the ministers here, that when a matter has been handled at the national court, you have exhausted all the courts in national court, you can again appeal to the East African Court of Justice, which the Council of Ministers did not wish to see. Now, who can access the court? A partner state can access the court against another partner state. Against a partner state or against an organ of the community or an institution of community, where you allege that there is a violation of any acts or regulations or directive, or the decision of those institutions violate the treaty. Now, so far, we have had only one case where a partner state has sued another partner state. I think this was 2 years ago, where the government of Uganda sued the Kenya government over the issue of importation of oil. I am yet to check if officially that matter was withdrawn, but I know there were some discussions which sort of solved the issue, but I'm not sure if officially it is no longer on the records of the EACJ. But imagine all these years, only once that another country has taken another country to court. Somehow when they have a dispute, they have a way of sitting down and solving them. Another person who can go to court is the Secretary General. But the Secretary General can only go to court after seeking permission from the Council of Ministers. Now, this is very tricky because you are telling the Secretary General to go to his employer and tell his employer, allow me to sue you. You can be sure it will never happen, and it has never happened. The largest chunk of cases come from legal and natural persons. This is me and you and companies resident in the community. Underline the word resident in the community. It is not saying citizen of the community, meaning you can be a citizen of one of the partner states of EAC, but simply because you are not residing within the community, maybe you are staying in South Africa, which is outside the community, you will have no access to the courts. And in fact, that matter was ventilated in courts, went up to the Court of Appeal, where for the first time we had a dissenting judgment. 3 judges said, yes, this person cannot access the court. 2 judges said, yes, that is wrong. He's an East African. He pays tax to East Africa. In as much as he does not live within the community, he should be given an access. That case was coming from Burundi, where this Burundi national was very honest in his affidavit just to say, I reside in America. Although the subject matter of the case were properties, land in Burundi. And the state attorney jumped into that and said, look, the treaty talks about resident. This person is not a resident. He is a resident in America. So he has no access to the court. Now, the dissenting two judges were saying, look, you cannot limit access to the court to a citizen of the community who contributes to the well-being and development of that country, who even pays taxes from whatever it does in that country. How comes you go out there and you are telling nationals who are residing outside there and who remit a lot of money to the country, telling them come and invest? So what that judgment was saying is that if you are a citizen of the community and you live in America and you invest back home, should anything go wrong, you cannot access EACJ. The could have had a point. It is a case, I always say, I wish a similar case comes up again. Maybe the judges might change their mind. Another important thing you need to note is that you must file the case within 2 months only of the problem you're complaining about. If it is an enactment, a publication, or a decision complained about, you must take it to EACJ within 2 months, or 2 months from the time you came to know about it. I recently saw a new case being filed about 2 months ago at EACJ, where something happened in January. But this person only got to know about it within the last 2 months. And he had quite proper evidence that somebody sent him an email telling him, look, you know, this thing happened in January. So that is when he was becoming aware. And he used that now to file the case within the 2 months limitation period. Unfortunately, very many good cases have been lost because of that 2 months limitation period. And then also you see when it says 2 months limitation period, depending on the months when it happened, somebody will have 60 days, another one might have 61 days. And also another one, if the month of February ends on 28th or 27th, it might have lesser than 60 days. But a month is a month, according to interpretation. Whether the month is 20 days or a month is 30 days, it is a month. So they say within 2 months. Not a very good provision, which we have always said the community needs to look at it and amend it. As I said, employees of the court, of the community, can also go to court to ventilate any issues they have according with concerning their contracts with the employer. Otherwise, where will the staff go if they had a problem with the employer? Then national courts and tribunals. This is where Article 134 comes in. There is concurrent jurisdiction between EACJ and national courts. The fact that a matter is touching on EAC treaty does not mean a national court cannot canvass that matter. It can do it, but while doing so, it must follow what the EACJ decided. So it simply applies what has been decided by EACJ. It cannot come up with interpretation. Interpretation is strictly left to EACJ. And we had such case, the first such case was, I think, in 2014 of Uganda versus Kyahuruenda, where the court held national courts and tribunals are entitled to attend matters involving violation of the treaty. And Article 6, 7, and 8, which form the bulk of the cases filed in EACJ, they are just justiciable before the national courts and the tribunals, the same way they are justiciable in EACJ. But in doing so, these tribunals and courts will not interpret, but will only apply. Because interpretation is a reserve of EACJ under Article 33(2), where the decision takes precedent over decisions of national court and tribunals on similar matters. How the court operates, we have the main registry in Arusha, which was now decentralized to all the capitals except South Sudan has not opened a sub-registry. Kinshasa has not opened a registry. Again, this was following Article 7, where we're saying the treaty shall be a people-centered. If it is people-centered, make it easy for the nationals to access the courts. We cannot say we'll have only the registry in Arusha and somebody is very far, somebody is actually on Atlantic Ocean in DRC, and you're telling that person to travel all the way to Arusha to file his documents. So we decentralized. We have sub-registries in most capitals. you don't need to go to Arusha. You can walk to any of those capitals there and file your case. Of course, documents have to be filed in English. In as much as EAC has now taken a position saying the official languages of EAC will be English and Kiswahili, English, French, and Kiswahili, the treaty is very clear that the language of the court shall be English. And unless that has been done, it doesn't matter what the summit has decided, it will remain English. Although documents in French or Kiswahili, and we get many of those, especially from cases coming from Tanzania, cases coming from Burundi, cases coming from Rwanda, they are just translated. As I said, there are several sessions in Arusha and both in the capitals. The minimum quorum is 3 judges, though most often than not, they seat 5 judges. And the rules also allow that sometimes you can have one judge deciding over some applications. Look at 2019 rules. Make that your Bible. Keep it close to you. Read it as you read the case laws. It will really enlighten you on the procedures of how to engage in EACJ. And there's also the court users guide, which you can get from the website. Of course, the registrar is the engine of the court in all matters of administration of the courts. Now, it is more than 25 years ever since this court was established. Is there anything we can say it has done? Yes. It has developed a lot of jurisprudence on the East African community law. It has promoted regional integration by clarifying some issues where partner states were violating the treaty, sticking to their national legislation that I'll be demonstrating later on. So things like the rule of law, good governance, human rights have really been upheld through the decisions of this court. And the court has always continued to highlight where partner states have failed in their obligations. We have a case management system there that is working just to make court processes easier. Now, there are some cases that were groundbreaking, and they'll always be remembered. One of them, the famous case, is Anyang' Nyong'o. This case involved members of parliament. You know, politicians always create problems. It involves about election of members of parliament to the EALA. This case it is out of this case that the treaty was amended. In fact, if you look at the treaty and you see anything in italic, know that it was not there before this case. Anything you find in the treaty in italic came because of this case. It is this case that created the appellate division of the court. It is this case that brought some changes in how the court operates. Created the 2 divisions. It is because of this court now we have a principal judge. Previously, it was just a 1-chamber court. If you lose, you go. In fact, you have nowhere to go. But now you see, if you lose, then you have an opportunity again to be heard at the appellate division. Another important case, of course, is the African Network for Animal Welfare. This is a celebrated case, especially in all the organizations that deal with environmental matters. Can you imagine a government being stopped from building a tarmac road because the tarmac road is going to pass in a national game reserve and it will interfere with the environment of animals? The court indeed stopped further processing of that road. The case of Praxeda Rugumba. Rugumba was a military officer who was held in Communicado for 5 months. Nobody knew where he was, but people knew he had been arrested. And as soon as this case went to court, the person was taken to court. At least he was produced. And also this case emphasized the notion of exhaustion of local remedies, because one of the preliminary issues the government of Rwanda came up with is that Rugumba had not exhausted local remedies. And the court said, no, you don't need to exhaust local remedies. East African Law Society against Burundi, Attorney General. Can you imagine you are barring a lawyer from practicing without giving him a hearing? The basic rules of governance, rules of rule of law. Hear somebody before you take any decision. He did that and the court said no. There was also, again, an issue of elections of EALA members, again, politicians. in Uganda. Many questions have been asked that why is it that most of the cases in EACJ are just about human rights and not about trade? Yet they thought this court is supposed to be handling matters that will facilitate trade within the region. One of the cases we have had, although there are not many, is BAT against Uganda government. The Uganda government woke up one time and said the products, BAT products from Kenya are from a foreign country, so they will charge duty on them. And the BAT ran to EACJ, and the court first issued an injunction, which was later on confirmed that no, you cannot charge goods from Kenya because goods from Kenya as if they are just from Uganda. We are in the same common market, so you cannot charge goods from Kenya taxes. The same thing again was repeated by the Kenya government in a case involving Kyo Limited, which was importing raw materials from Tanzania. And the decision in BAT was followed in the case of Kyo Limited successfully. That Kenya, you cannot charge tax, you cannot tax raw materials from Tanzania coming into Kenya. We have our own Emily here on this platform. She saw Kenya was not doing right. Kenya was purporting to enter into a free trade area with the US. Yet here it is in a common market, which cannot work. And she herself was a party. She sued the Kenya government and indeed succeeded. Then you have the famous case of Martha Karua versus Attorney General. This is Karua 1. We call it Karua 1 because I think there's another one pending, Karua 2, where she went to court challenging a decision of the Supreme Court, but not seeking to overturn the decision of the Supreme Court of Kenya. All she wanted was that the EACJ to declare that whatever the Supreme Court of Kenya did violated the treaty. And indeed, the court found that the judiciary of Kenya violated the treaty in the way her case was handled. So, having said so, what do you need to know? What strategies do you need to keep in mind when you are filing a case? First of all, who are you suing? You cannot take me to court. If you look at Article 28, 29, and 30, it says very well who can be sued. A partner state, the Council of Ministers, or an institution of the community. So if you go there and sue me, I'll just raise a preliminary objection and your case will be thrown out. And we have had cases like those. The case of Modern Holdings versus Kenya Ports Authority was the first one. Obviously, Kenya Ports Authority is not an institution of the community. That is a parastatal in Kenya. But now, instead of Modern Holding suing the government of Kenya and saying, look, the government of Kenya through your agent, Kenya Ports Authority, you did ABCD, which was a violation of the treaty, they went straight for the neck of KPA. Of course, the case was dismissed. Then very recently, not long ago, Contrails Investment sued the Central Bank of Kenya, again claiming that Central Bank of Kenya, which is established by an act of parliament in Kenya, is an institution of the community. And the case went on. At first, when the respondents raised a preliminary objection, sorry, the court ruled that whether central bank is an institution of the community or not is a matter of evidence, which to me, that ruling was wrong. If you are a judge of the community, surely you know how institutions of the community are created. You should have taken judicial notice of how the institutions of the community are created. But because he said it's a matter of evidence, fine, the matter proceeded. And who came to swear to give evidence that the Central Bank of Kenya is not an institution of the community is the CTC himself, swearing an affidavit that, look, Central Bank of Kenya is not an institution of the community. And on that ground alone, the case was dismissed. And then another interesting case, BAT Uganda versus Uganda Revenue Authority. Now, this case was interesting for two reasons. Here we have two government institutions who cannot agree. Uganda Revenue Authority And no, sorry. Before I get there, on this point of the defendants, if you look at Modern Holdings, had Modern Holdings sued the Attorney General of Kenya, most likely the case would have succeeded. And that is what PAT Uganda case did. The culprit was Uganda Revenue Authority. But the PAT did not go for Uganda Revenue Authority. It went for Attorney General of Uganda and said, you see, Uganda Revenue Authority is an institution, an agent of the government of Uganda. And that's how the case succeeded. Now, comparing that case with URA, the next one, versus AG Uganda. This is now Uganda Revenue Authority, which was suing Uganda Airports Authority. Two government agencies cannot agree. That, of course, it came as a surprise with that two government agencies cannot sit and talk, they have to take one another to court. Now, the second interesting thing about this case was that instead of going to the Uganda courts, they chose EACJ, which to me was a tick of confidence that government authorities sitting in Uganda cannot even trust their own institution there. They have to come to Tanzania, the EACJ. However, the matter did not proceed. They later on realized the mistake they did, and I think Uganda Revenue Authority was asked to withdraw the case so that they solve it at home. That was done. Another important issue which you must look at is when was the cause of action? When did it arise? This refers to Article 32, which I've talked about the issue of 2 months. Somebody like Malema Berizi filed very many cases. He files very many cases. And there's a time he had a case which had a mixture of computation of time. One of the issues he was complaining about was already out of time. Another issue he was complaining about was still within time. So what the court did was just to strike out the issue that was beyond 2 months and still maintain the case. And he was advised that he'll only proceed with the case on the matter that was within time. Now, many people, when advised about this Article 32, don't take it seriously. So what they do, they file a case, knowing very well it is out of time. Then now they come with an application for extension of time of the 2 months limitation period. Now, this 2 months limitation period is not in the rules. It is in the treaty. It's like it is in the Constitution itself. You cannot use the inherent powers of the court to extend those 2 months. So it is either 2 months or you are out. Now, when you get the experienced state councils nowadays we have, the Nicholas of this world on the other side, he'll just wait for you and have your matter struck out because it is out of time. 3, don't be confused and start going for exhausting local remedies. Article 7 of the treaty talks about people-centered. So go straight to where your problem can be solved. The moment you say you want to exhaust your local remedies, by the time you get to Arusha, it will be 5, 6, 7 years, surely. Where is the 2 months? And that is what Praxeda Rugumba was saying. Another big problem, I think, again, what people don't realize is the issue of res judicata. Somebody tells you, I cannot go to EACJ because you see this matter was already decided at the national level. No, it may have been decided at the national level, but you are going to EACJ on a completely different cause of action. The parties could be the same. The subject matter is the same. But in that subject matter, you have violation of the treaty. And that's what happened in the Martha Karua case. The respondents were saying Martha Karua has filed a case in EACJ, which is just a disguised appeal. And her lawyers were saying, no, this is not a disguised appeal. When we were in the Kenyan courts, we never said you have violated the treaty. We never said. But here we are saying, on those same facts that were canvassed in the Kenyan courts, you violated the treaty. So this is not an appeal. Secondly, she was not even asking EACJ to overturn the decision of the Supreme Court or the decision of the Court of Appeal of Kenya. She was not saying that. She was saying declare what this court did violated the treaty. And that's what she got. Something else you must consider is when you are writing your submissions. Some lawyers put in very, very long, boring, irrelevant submissions, out of the point completely. Now, when you do that, what happens? Even the judges have no time to read it. You have hidden a point you'll have said in 2 sentences, you have said it in 5 paragraphs. Somebody reads, gets bored, says this one is saying nothing, and dismisses your application. Just be concise and on the point, then you'll attract the attention of the person who is hearing this case. That applies both to the applicants and the respondents also. When it comes to scheduling conferences, again, this is where I've noticed a lot of repetition. Somebody takes everything which was in the pleading, in the application, and everything which is in the response, and puts it in the scheduling conference. Why are you repeating that? The purpose of scheduling conference is simply to come up with the points of disagreement, to agree on the issues that you are asking the court to converse about and give you answers. Not to repeat what the judge has read in the application, not to repeat what the judge has read in the response, and very many other unnecessary documents. So prepare and prepare and prepare and prepare and prepare. When judges have read your files properly and you are not prepared, they will ask you one question which will put you off balance completely, and you'll be done, my friend. And once you're done, you can be sure your case will be thrown out. Cite verifiable authorities. Some people think this court has no time to read. So others even cite non-existent or fake authorities, just as a way of trying to support their case. No. For your information, the court always goes through those authorities. Some of them, they exist, but they have nothing to do with that case. But you find somebody that put it there. Others don't exist, or others exist, but somebody has completely changed the facts to try and convince the court about his case. It can't work. When it comes to appeals, the appellate court is very, very strict on timelines. Very strict on timelines. You will rarely be allowed an extension of time if you don't have a good reason. We had 2 cases where the Attorney General of Uganda filed notice of appeal. And after filing a notice of appeal, he went to sleep. Then after 1 year, the other party now puts in a notice to strike out that notice of appeal. The Attorney General now wakes up and files an extension of time, an application to extend the validity of the notice of appeal after 1 year. So the court asks, so what made you file a notice of appeal? You have stayed more than 1 year to come and seek for an extension for you to file the appeal. And they give this flimsy excuse that, the office was shifting from Dar es Salaam, going to Dodoma, so they filed. Surely, is that an excuse? We are dealing with a corporate office. Is that an excuse not to file an appeal? Of course, the court declined. Their notice of appeal was struck out. So stick to Article 35A. You appeal on a point of law, you appeal on procedure, and you appeal on defectiveness of the appeal, of the proceedings in the lower court. One thing that amazes me when I talk to most lawyers, ask them, why aren't you filing matters at EACJ? I always get a stereotyped answer that, we don't file because I don't see the cases to file there. And within 5 minutes, I'm able to quote about 5 instances of what has happened in their countries of cases they can file there. Now, most of those cases are public interest litigation. In fact, the rule of the thumb is any government that violates its own laws which it passed in their parliament, that is straight away a violation of the treaty. But you find somebody telling you he doesn't see cases to file at EACJ. simply because most of those cases are public interest litigation. The case filed by Emily, that was a public interest litigation. But look at the impact it had. So if you cannot file a public interest litigation because you feel nobody is going to file your fee, then you are complacent in violation of the treaty. You are part of the system that is helping and encouraging your country to do in bad governance, violating the rule of law. Go and file, you don't have to pay. That way, and then you'll be helping your country to observe good governance and maintain the rule of law. So there are very many cases to be filed. Forget about the challenges the court is undergoing now, but if you talk about filing cases, there are very, very many cases there to be filed. Like any other institution, there are challenges. The first one here is the court not having an enforcement mechanism. That does not, however, mean that you cannot execute. In fact, nowadays, when somebody tells me you cannot execute a decision of EACJ, I blame that person. Provisions of executing are there. Don't you ever file cases against the government in your own countries? How do you execute those ones? In the same way, you get a decision against your government, you execute it in the same way you will have executed a judgment against your government given by a national court. Fine, the court may not have a mechanism, but that has been transferred to your local mechanism, so it should be easier. The 2 months limitation, which you have said, this is a problem. You cannot sit in a country and say, going at the national court, you must go there within 2 months only. Yet at the national level, if you want to sue the state, you have 1 year to sue. And again, this 2 months limitation period, again, if you look at the treaty, it is in italic. It was introduced after the Anyang' Nyong'o case. Because one of the problems the heads of state had was that these issues of Anyang' Nyong'o case happened long time ago, over a year. Why is the case coming now? And the heads of state were advised that, you see, there is no limitation. So they told the attorney general, go and introduce a limitation period. And then instead of reasoning properly and said, okay, maybe we give it 1 year, they actually gave it 2 months. The idea was to try and frustrate people, harass people, not to be filing cases in EACJ. That, however, has not worked. Many cases are still going there. There is the ad hoc working nature of the court. Only the president and the principal are resident there. These other judges, they are back in their countries, and they only go there when they are called. This issue of 7 years fixed term, we think, in my view, it is not proper. Maybe that term needs to be extended and then provide for only one way of judges existing. Currently, there are 2. You will exit the court as a judge because you have served 7 years, or you will exit because you have hit 70 years. So a judge who is appointed when he's 68, he will serve 2 years only. Will we really have benefited from his wisdom and experience? No. So that even if a judge is appointed when he's 69 years, let him do 7 years. After all, they say it is at those ages that somebody is very wise, somebody is very reasonable. So something needs to be done there. Visibility. I really tried working on visibility when I was still in Arusha, and I'm glad, though we haven't reached there, people know about the courts. In Kenya, you always hear, especially politicians, people quarreling and saying, if they refuse, we'll go to Arusha. If they refuse, we'll go to Arusha. That means they know there's a court there existing that can listen to us. And you'll find now that even governments are not hostile to people who go to Arusha, except maybe 1 or 2. One time when we were doing a visibility sensitization in partner states, somebody confronted me and asking me, why are you telling people to go to court? And he was a government official. And I told him, so why did you set up that court? And then if you don't want people to go to court, don't you pay judges there? So you want them to do what there? If you don't want your nationals to come to court, then lobby the other heads of state. They disband that court. Otherwise, mine is to encourage people to make use of that court. It will help all of us, and it will help the integration of the community. Of course, limited budget. This is linked to currently the problem the court is having now. More better innovative ways of raising the budget of the court needed to be explored. I'm sure some things are on the table for discussing this issue, how the budget of the court can be improved. It's a question of time. I hope it will be it will be approved and implemented. I think I want to stop there, and I'll finish by saying, please take up public interest litigation. To me, they are more important. The moment you improve governance in your country, then the more you improve the rule of law in your country, the more you are practice, you are able then to get more clients coming to you. Than being complacent, you are seeing your government violating the rule of law, violating good governance, and you cannot come to Arusha simply because nobody will pay you. I think that is not proper. Thank you very much.
Wow, wow, wow. Wow, wow, wow. Ladies and gentlemen, please join me in extending our heartfelt gratitude to our keynote speaker. For those who have just joined us, he is His Worship Eufunalis Okubo. He is the former registrar of the East African Court of Justice, and his insightful address has given us a clearer understanding, and I should say a more authoritative understanding of the court's structure, divisions, and jurisdictional mandate. Personally, I'm grateful for the practical guidance on the procedure rules, the filing requirements, achievements, litigation strategies, compliance best practices, and the challenges he has shared. These tools will undoubtedly enhance our effectiveness as practitioners before the EACJ. And I love the fact that he gave us his unique perspective that he has drawn from all the years of his service at the very heart of the court as a registrar. Your Worship, you have enriched our session very immensely. You have enriched it immensely, and I am glad we have over 80 litigants who are going to be filing public interest litigation suits and be the change that we want in the EAC here in this session. Your Worship, you have also guided us on all cases that didn't succeed, and now we know how to better facilitate ourselves when we are planning to file a case before the EACJ. And at this point, ladies and gentlemen, I would like to open the floor for questions. And some have shared their thoughts in the chat. I'll read a few of those questions in the chat. And if anyone has a question, I don't know whether someone from the East African Law Society is around to help. But in case someone has a question, you can share it in the chat or raise your hand, and we shall take 5 questions before we go to the next session, or 3 questions. Prior to the breakout, we listened from the former registrar of the EACJ, who gave such practical guidance on procedure rules, filing requirements, achievements, litigation strategies, and compliance best practices for practicing before the EACJ. Now, we wanted to go through the questions that were sent through the chat, and unfortunately, I think we have lost most of them. But there's a question I noted, Your Worship, which is, why is the appointment of judges political? Someone raised it. I didn't get their name. Maybe you can help us answer that as we receive questions from the attendees. Please share your questions in the chat so that I can be able to address them and forward them to our keynote speaker.
Yes, these appointments, they look political. First, it is historical. The first bunch of judges, those are the ones who delivered that hard-hitting judgment on Anyang' Nyong'o. And the heads of state did not like it because it was like a confrontation between the judges and the heads of states. The words the heads of state used in the summit against those judges are words we wouldn't want to repeat here. Things like, who do they think they are? How can they stop us? These judges were appointed them to come here and then they can issue orders barring us from holding our meetings. So from that, there must have been a feeling that now we need to get people who are compliant. Unfortunately, I don't think they have succeeded in that. Particularly the last crop of judges, which were headed by the current Attorney General of Rwanda, they issued a lot of hard-hitting judgments against governments. Some of you know the famous case of UTC in Rwanda. That was a case that was making people panic. But what did they do? They hit Rwanda in the first instance, they appealed, and they hit them harder. I remember that day I was sitting in my office, one of the judges comes laughing and telling me, we have hit them, put your ears on the ground and listen what they are saying. Then after 1 week, I told him, my lord, they have said nothing. He said, sure. I said, yes, they have not. I said, you see, some people are just panicking for nothing. So that could have driven judges to think, let us appoint judges that are friendly. But I've hardly seen that. Few will try to dissuade the others to go the wrong way. Remember, first of all, you are sitting a bench of 5. If 4 of us have taken a certain decision, how will you convince us? Because the case is against your country? In fact, somebody asked me, why do judges sit on a case that is emanating from their country? And our answer was, it is better when you have, let's say the cases from Kenya, it is better to have a judge from Kenya. That way, it will make the government very easily accept that judgment because our own was there. In the African court, when a case is coming from your country and you're a judge there, you will not be put on that panel because they think the other judges will be independent. They think if you sit on that panel, you can influence, which to me, I don't think that is correct. In fact, African court judges sit more than 5. I think they sit 10 or something like that. Surely you one judge, because the matter is coming from your country, how will you influence the other 9 to change the decision? So that would have informed from a Anyang' Nyong'o case, that would have informed the appointing authorities to think of appointing those who they think are compliant. Of course, I can say this, we have also seen where some appointments appear to be rewarding. Because we have done a very good job here at the national level, now we will reward you by taking you to an international court. That sort of has compromised the work of the court in terms of quality. We end up not getting judges that are really not material for an international court. But people who just come there because they've been rewarded, you may have done something completely different at the national level. But because your government wants to reward you, they send you there. It is not as bad as in the quota, the way it is in EALA. I think we have seen in EALA in some countries where after you fail an election, then they nominate you to go to EALA. Or they tell you step down, don't worry about this seat, we will send you to EALA. Whether the person interested in EAC matters or not, that happens. That is the way I look at it. Thank you.
Thank you very much, Your Worship. And on that note, I would want us to move on to our panelists. Briefly, our panelists are partners and accomplished practicing lawyers who bring with them a wealth of experience in regional and international litigation. We have heard from His Worship, Euphnalis Okubo, and we know how the court operates. We know its mandate. And now we are going to listen from the users. We are going to listen to the users of the court who have appeared before the court, and in addition to appearing before the EACJ, they have appeared before tribunals at both national and regional levels, and they have guided clients through some of the most complex disputes in areas ranging from commercial law to human rights, treaty interpretation, and cross-border trade. By names, these partners are Emily Kwamboka Osiemo. She is a partner at Lumumba and Ayeko Advocates. We also have Jebra Kambole, who is a partner at Logards Advocates. If you were here earlier and you listened to his worship, he gave you insights on the case Emily Osiemo filed, which is Emily Osiemo versus the AG of Kenya. And you know for a fact that we are going to get very practical insights from our panelists. And today we shall be sharing insights on 3 key pillars of practice before the EACJ. Our panelists are going to guide us through litigation strategies and case management, where they will delve into persuasive pleadings, effective evidence handling, and tactical use of preliminary and interlocutory procedures under the EACJ. They'll talk about the opportunities for legal practitioners, highlighting emerging areas of practice, advisory roles in compliance and dispute avoidance, and how to build a niche around EACJ litigation and advisory services. They are going to give us the best practices and lessons they have learned over time, and will offer us valuable perspectives from the cases they have handled. And since we know that they have won these cases, they'll give us winning strategies and common pitfalls, as well as guidance on building a strong professional reputation in regional litigation. So our two panelists have a unique combination of practical courtroom experience and strategic advisory work. And I believe we are not going to leave this place the same. So ladies and gentlemen, let's welcome Emily Osiemo and Jebra Kambole. But to start with, we shall have Emily Osiemo give us, speak to us for 20 minutes, and then we shall hear from Jebra. And later, I kindly encourage you to send through your questions through the chat. Our keynote speaker is still in the room, and the panelists will still be in the room, so that they can answer any questions you might have. Thank you very much. So Emily, over to you. Thank you.
Thank you so much, Mabel. Please, you will notify me once my time is up. And in the event you lose me, kindly let me know as well. Dear participants, listeners, and colleagues who are joining us, based on a few matters we have appeared before the court and the experience, I thought it would be wise for me to talk about a few strategies for drafting of pleadings before the court, as well as submissions, and even how to handle evidence and how to leverage on interlocutory application, preliminary rulings, and appeals. I'll try to be slow so that everyone will hear me clearly. Now, before drafting any documents, because this is an international court, one is not raising domestic matters there. Therefore, the people who are going to be sued are governments. And these governments are represented by an attorney general. So when you file a suit at the EACJ, you sue the attorney general. We have a few states that joined, like Democratic Republic of Congo, South Sudan, whose AG is called a Minister of Justice. So you have to be very clear, who are you suing? Number two, and why I'm raising that, it's very important because you find people dragging parties there. For instance, they want to sue, let me give an example, maybe a tax agency in the state. For instance, in Kenya, Kenya Revenue Authority, or in Tanzania, Tanzania Revenue Authority or URA in Uganda, among other states. So those parties cannot be sued. You can only attribute their actions to the government, so that then you will now connect how whatever they have done is attributed to the state, considering their state agencies. So number two, before drafting any documents, it's important to be aware of what the treaty provides and the nature of matter you want to file in the case. So that then you need to read some of the provisions of the treaty so that you know which law are you going to apply. Are you going to use the treaty? Is it a protocol? What kind of, you need to read widely so that you are able to understand how the court works and even the decisions of the court, because those decisions then will guide how the court is going to deal with the matter, because some of the matters we might be raising as litigators are matters that have already been litigated. So they'll not be new. Now, another thing I have learned from my experience is that once you are sure of what you are drafting and who you are suing and the nature of the claim, normally a course of action before the EACJ is established by way of showing violation of the treaty. The EACJ's appellate division has held that once someone or a party or a litigant alleges violation of the treaty, so you cite the provision of the treaty and how whatever actions the government has taken violates the treaty, that in itself is a violation of the treaty and it's a course of action. That has been held in the case of Attorney General of United Republic of Tanzania versus Africa Network for Animal Welfare. If you look for that case, appeal number 3 of 2011, you'll find some of the details there. So therefore, that's how one establishes a course of action. Now, a pleading must have, of course, who you will sue, then the course of action. That's what I'm trying to say. How will you establish a course of action? Then the next thing before you start drafting, have your rules and the treaty there, so that then you are compliant with provisions of the rules of the court. We have the EACJ rules of 2019. Those rules should be there to guide you hand in hand how you draft. If you are suing a government because of violation of the treaty, then Rule 25 of the Rules of Procedure of the Court of 2019 will be there to guide. What do you need to establish? For instance, part of the particulars is you need to say who you are, your addresses, and those kind of details. Then you need to state the respondent and give their particulars. And then after that, you need to give the subject matter. The subject matter means now the violation, which kind of provisions have been violated and the facts relating to that violation. What I also think is important is that when drafting pleadings, it's also important to have at the back of the mind that I need to know, is this court the right court? Does it have jurisdiction to deal with this kind of issue? If it's a violation of the treaty, is it under Article 27.1? Does it fulfill the requirements of Article 27.1? Will be you seeking interpretation and application of the treaty? Then another issue is, are you within time? If it's a legal and natural person, one of the requirements is that the person has to have filed it within 2 months from the time the course of action arose. And when a suit is filed beyond that time, of course, even if the pleadings will be very good, the matter will be struck off. So once that has been done, it's important for one to have a checklist to tick what have you done and what have you not done in your pleadings. I really discourage precedents, because you can copy someone's precedent and then you find perhaps that suit was dismissed on a technicality. And indeed, the government, state councils watch keenly the pleadings because they have mastered the arts of technicalities. so they know where to knock it out. It doesn't matter, even if it's a new time one is handling a matter at the EACJ, it's rather important you start from zero, then you perfect. You can even have a colleague to look at what you have. Some of those who practice there to check what you have drafted so that they can advise rather than copying a precedent. The other important factor that I thought it's important to discuss is that once pleadings are being drafted, it is also important to understand the issue of locus standi. If this is my client is a natural person, for instance, I'm representing, I need to declare where they are resident so that the affidavit they will have signed, which supports the reference, because when drafting a reference, for instance, by a natural person, it must be supported by an affidavit. If it doesn't have an affidavit, it will be struck off. So that affidavit must be signed within a residence of the community. So it can be signed in Nairobi, can be signed in Kampala, it can be signed in any other city or town, but within the community. So that if the affidavit is signed outside the community, as the Honorable Registrar had said, that matter will be struck on technicality because of the issue of lack of locus or lack of the jurisdiction of the court. The court will say we lack jurisdiction because the person is not a resident within the community. And that was held in the case of Manario Desire versus the Attorney General of Burundi. That's a very important decision that one has to have the back of the mind when drafting. Another thing that I thought I should speak about is that when drafting, we need to have clarity of issues. Sieve out the issues, what kind of issues you need to raise, and link them to the treaty provisions and how the violation has taken place. And once that is done, the prayers should also be clear. So many years, most advocates have been requesting for declarations, until even some judges were complaining that, you see, you only come and you sue a state and you're only seeking for a declaration. We should never only stop at seeking declaration, but seek other orders that are visible within the nature of the case one is filing. For instance, if it's a person who has been abducted and it's a nature of a human rights case, one has filed a reference citing violations of the treaty, specifically Article 6D on the principle of human rights and those kind of rights, and 7.2, then when now seeking remedies, you can even seek orders against that state, perhaps to release the person and even seek compensation, so that people should only not seek declarations. The other thing I thought it is important when drafting pleadings is that we also, when drafting, we also try to think, what does the other side, how will the other side perceive my pleadings when they receive them? What are the likely loopholes they will see? That then helps to tighten the loose parts of the pleadings. Because once you review and you see, if I file this the way it is, the age is likely to raise this PO, then that helps in now, when it comes to submissions, the important point that I learned from the court is that the court is persuaded when you use their own precedents, starting with the appellate division's decisions. Because if you're appearing at the first instance division, that first instance is bound by the precedents that have been set by the appellate division. Therefore, if, for instance, it's an issue of locus standi, and maybe one signed an affidavit, and that affidavit is deemed to have been signed in, say, Nigeria, in Abuja, then appeal is raised. So the case that will be cited is an appellate decisions case, and the first instance division will have no option other than to hold according to the appellate divisions. So therefore, to be able to write very good submissions, of course, they have to be succinct, short, precise, and clear on issues. Normally, before you write submissions, we normally have scheduling conference. Now, during the scheduling conference, parties agree on issues as to issues that they have no dispute and issues where there's a dispute. And then the court, based on that, then it will help you now to address the court on what are the issues before the court, especially those issues where there's a disagreement are then the issues you raise in the submissions. Then when addressing those issues, start with decisions of the appellate division if they are available. If they are not available, the first instance decisions can be used, but they are persuasive. Domestic cases can be used and other international courts can be used, but they are persuasive in nature. Any other thing I might wish to say is that please, during drafting, remember to always look at the rules. Never draft a reference or any pleading for the EACJ without looking at the rules. The rules of procedure will guide as well as the treaty. For instance, if one was drafting an appeal, there is no way you can draft an appeal without looking at Article 35A, which says that what one can appeal, they can only appeal on points of law, they can challenge issues of jurisdiction and procedural irregularities. Therefore, that then helps so that when drafting, a mistake is not done. Now, another thing in terms of evidence, what I have learned based on my own experience is that one, any case that challenges illegality or violation of the treaty must be supported by an affidavit by the applicant. So that applicant has to file an affidavit. That affidavit, according to the EACJ, is evidence that has been held in the case of UTC versus AG of Rwanda, appeal number 1 of 2015. If you look at that decision, it says that an affidavit is evidence. That affidavit has to be commissioned. If it's being, for instance, signed in Kenya or in Nairobi, deponed in Nairobi, it has to be signed by the deponent in Nairobi and then commissioned by a qualified advocate who holds a practicing license within the national bar. As long as any advocate who holds a license, who is licensed, they can commission. All annexures to that affidavit have to be properly commissioned. If that is either they can be commissioned or notarized, any of them is okay. In this case of UTC versus AG of Rwanda, the EACJ said that if an affidavit is done, those annexures have to be commissioned. If they are not, they'll be struck off. Point number 2, I have learned in terms of evidence management, an advocate should never sign an affidavit or should never depone a supporting affidavit for a case for an applicant. If, for instance, the applicant is X and I'm the advocate representing that and drafting pleadings, I should never prepare a supporting affidavit in my name. That affidavit will be struck off. In the case of Attorney General of Burundi versus Secretary General of EAC, in that case, an advocate filed, one of the advocates in the Attorney General's chambers in Burundi filed an affidavit on behalf of the government of Burundi. And it was the same person who appeared in court. And of course, the appellate court said that that was already not only procedurally not proper, but that advocate then cannot appear before the court. It will not be a competent affidavit. Another issue I have learned that I also thought about issue of evidence is that during evidence before the EACJ can be viva voce, where the deponent or those parties are called and they're able to give evidence and they're cross-examined, or it can be done by way of affidavit. So it depends. During scheduling conference, or which we sometimes call pre-trial, parties agree how will the evidence be produced. Is it by way of a viva voce? Viva voce is where a witness comes and they are cross-examined and they give evidence. or is it going to be by way of adopting the affidavit evidence? And both sides are allowed. So once parties agree on the nature of evidence, then they have to follow that. Electronic evidence is allowed before the EACJ, but that evidence has to have sort of a certificate of that says where was it obtained from, who obtained it, is it reliable evidence? There are some principles that EACJ has laid down in the case of East Africa Law Society versus AG, Attorney General. Sorry, when I use the word AG, I mean Attorney General of Uganda. That is reference number 2 of 2011. It said that if one has to produce electronic evidence, it's only admissible if they're able to say how the manner in which it was obtained, whether it has been maintained in that standard, that it is not been corrupted, and which source, those kind of details, and whether it's reliable evidence and there's no prejudice to the other side. Illegally obtained evidence before EACJ can be allowed. It's not the same as, for instance, in Kenya, where illegally obtained evidence, there's a decision of the Supreme Court of Kenya that says illegally obtained evidence cannot be admissible. But in the EACJ, illegally obtained evidence, even if where a party has not disclosed how they obtained it, it still can be admitted. And this was observed in the case of Anthony Komu versus the Attorney General of United Republic of Tanzania. Additional evidence. So normally what happens, once you file a reference, you serve it. The Attorney General of the state that has been sued has 45 days within which to respond. Thereafter, once they have served the response, the applicant and their counsel has 45 days as well to file a rejoinder if need be. If no rejoinder has been filed, then pleadings will close. So once pleadings close, what normally happens is that there is no additional documents that or evidence by way of affidavits and such kind of documents that can be produced until leave of court is sought. So that's very crucial. Evidence must be in English. And I emphasize this because of a case where I appeared and documents had already been filed, but they were not in English. So the other side put a PO. So to correct that, we did an application. When we came on board and noticed that documents had been filed and they didn't do that, so the quick thing to do was to prepare an application and as well explain to the court why this was not done on time, and as well support or attach now the translated documents. So all documents must be in English, otherwise an advocate will face appeal. In terms of now, how do we use issues, or how do we use preliminary rulings, interlocutory applications and appeals in complex matters, sometimes as an advantage? Of course, not all the time, not all violations of the treaty must be filed at the EACJ. There are violations of the treaty that can be filed at municipal courts or our national courts. If you look at Article 33 of the treaty, it says that that can be done. And there's a decision of the EACJ where it has said that it will be absurd if EACJ will have jurisdiction and deny national courts jurisdiction to hear matters of violation of the treaty. They can hear. The only issue they cannot is they cannot interpret the treaty, or they cannot declare violations of the community. Where there are violations, directives, which are done by the community specifically, that one they cannot. That has to be referred to the EACJ. So national courts have jurisdiction as EACJ. They can deal with matters of violation of the treaty. However, they cannot deal with matters of interpretation of the treaty and decisions, violations of decisions, directives of the community. So where that happens and you have maybe filed a case in any of our partner states, a case has been filed in the national courts, and an advocate notices that there's an issue of interpretation of the treaty, that then it's important to let it to the attention of the court so that now the court can use what we call as preliminary rulings. Preliminary rulings means that they will now refer the matter to the EACJ for the EACJ to deal with only the aspect of interpretation, return back the decision to the domestic court, then the domestic court now will determine the case based on the interpretation given. That is what we call preliminary rulings, and they are guided by Article 34 of the treaty. Now, not all the time one needs preliminary ruling. They can only be exercised where interpretation is needed. However, in some instances where the EACJ has already decided a number of cases and given an interpretation of the issue in question. Let me give an example. For instance, if I want interpretation of Article 6D and 7.2, those interpretations have been provided in so many cases, including even the recent decisions of Martha Karua, Male Mabirizi, and others. Therefore, if I have that issue before the National Court, I don't need to use preliminary ruling or refer the matter to the EACJ. Because there's already decisions of the EACJ, all I need as an advocate is to bring them to the attention of the National Court, and the National Court can use them as guidance and apply them to the decision. The other time one does not need to use preliminary ruling is that if the question of the treaty is not a subject of the suit. Yes, the treaty is cited, but it's not a subject of the suit. The suit maybe is about personal injury or failure to remit taxes. It doesn't have an issue to do with the treaty. Or sometimes when the interpretation is obvious. So those are the instances when a preliminary ruling is not necessary. And there's a decision of the EACJ on preliminary rulings that has guided in the case of Attorney General of Uganda versus Tom Charwenda. I'm not a Ugandan, so that name normally I struggle to pronounce it. Now, in terms of interlocutory applications, they are important in sometimes dealing with matters where if these matters have to wait until the court hears and determines, the subject matter might be overtaken by events, or there might be damages that can be occasioned to the applicant. So therefore, as an advocate, you will draft the reference together with an application and a certificate of urgency. That application is by way of the certificate, the notice of motion, and a supporting affidavit. So that then, if one needs, for instance, injunction, what they need to demonstrate to the court are threefold issues. And this is guided by the case of American Cyanamide case, which normally EACJ normally applies in all its decisions of interlocutory applications. So what we need to demonstrate in interlocutory application, for instance, if it's an injunction, one needs to show that there are serious triable issues. What are serious triable issues? Serious triable issues is that there's a serious course of action. The reference discloses a course of action or an issue of infringement of the treaty. As long as that has been alleged, that is a serious triable issue in my view. And that one can look at the case of BAT, that is British American Tobacco versus Attorney General of Uganda, how the court dealt with applications. Now, another issue is that whether the applicant is likely to suffer injury that cannot be compensated by way of damages. This is very important. If the client is likely to suffer irreparable damage that cannot be compensated by way of damages, then that party ought to allege that and also support it with evidence. I'm happy that in the case of Kio that was cited by Honorable Registrar, in that case, what happened was that a Tanzanian company that operates in Kenya was importing glass from Tanzania. And then Kenya passed this finance legislation to increase excise duty to those products from Tanzania as if they are out from outside the community, which was discriminatory. So when the Council on Record filed the reference, she filed it together with an application. And that application was able to show, the applicant was able to show that one, how you can demonstrate damage is that one, the party who is in question is likely, for instance, not to compensate the money in the event the case succeeds. The question was that KRA wanted money, and they were able to demonstrate that this KRA, even if the applicant was to pay, the likelihood of refunding the applicant money when the case succeeds is very minimal, and they supported it with evidence. Further, it was able to be demonstrated that the damage was in a manner that it was difficult to assess. For instance, they were able to show that there will be loss of business, among other things that would not be able to assess, among other issues. So one has to demonstrate by way of evidence that there is a reparable injury. And the last aspect is balance of convenience. So this depends on the court now looking at balancing the scale of justice and weighing on that. Now, on issue of appeals, I'll comment briefly. Article 35A of the treaty provides that there are 3 limbs under which one can appeal. From the first, if one is dissatisfied with a decision of first instance, they can appeal to the appellate court. They can only challenge 3 issues, either errors in points or errors in law, errors in terms of jurisdiction, that the lower court or the first instance purported to exercise jurisdiction which it lacks, or errors in terms of procedural irregularities. For instance, they didn't allow the evidence of a party, they didn't consider it, among such kind of issues. So if one raises errors of fact, those are matters that EACJ will not entertain. And if an appeal is filed, it will be struck off. Now, how is an appeal dealt with? One
Please
has to
wind
file.
up.
Yes.
Yes, please wind up. You have a few minutes left.
Thank you. I'll finish in 2 minutes. So what normally happens if you are dissatisfied with the decision of the first instance, one has to file a notice of appeal, and that notice of appeal has to be filed within 30 days. The notice of appeal is just this. If you are practicing in a common law jurisdiction, it's just the normal notice of appeal. You state that you are either dissatisfied with the whole or entire judgment of the first instance. Then you if it's part, then you say which part you are not dissatisfied. And then after that, then you file it within 30 days from the date of the decision. Then after that is done, you file a memorandum of appeal within 30 days from the date the notice of appeal was lodged. Those timelines are very important to the EACJ based on how judges handle applications that have been filed that one was not able to file a notice of appeal on time. The EACJ has been very strict on timelines. Then after that, basically, after the notice of appeal has been lodged, then a memorandum of appeal is lodged within 30 days together with the record of appeal. What does the record of appeal contain? It contains the proceedings of the first instance, the judgment, the decree, and pleadings that were filed before the court. I think that will be all. Of course, after that is done, scheduling conference is done. Scheduling conference is sort of a pre-trial, and then the court will guide now how parties will make submissions, and thereafter a judgment is date is given for the appeal. Thank you for listening to me. Thank you.
Thank you very much, Emily. So Emily Osiemo is from Kenya. I forgot to mention that, and she has ably shared on the litigation strategies, case management, and as our keynote speaker noted earlier, there was a complaint that the EACJ listens to only human rights related cases. And I think with Emily, you know that you can bring all your trade related cases that affect that contravene the treaty to the EACJ. And now we have Jebra. Jebra is a promoter of human rights. So I think he'll give us insights on that human rights angle. And without further ado, please let's welcome Jebra from a partner at Law Guards Advocates. Jebra Kambole, you're welcome. And he's from Tanzania, so we shall get a view from someone from Tanzania.
Thank you so much, and thank you all participants, and thank you East African Law Society for organizing this meeting, seminar. We really appreciate for that. But I will try to be very brief because a lot of issues has been discussed by other panelists. So most of the issues that have been discussed. What I will do is just try to share my experience as a human rights lawyer from Tanzania. To my experience with the East African Court of Justice, my first appearance was in 2015. So I might have more than 10 years, or almost 10 years with the court. So a bit senior before the court. And I started to practice when I just have 2 years of practice. So I can say that anyone can appear in court. And you can't compare this court with the national courts. This court is somehow friendly with the councils. So at least when you appear before the Eastern Court of Justice, you can feel that you are in international court. And you can see that as applicants and the other side with the state attorneys, you feel comfortable that you are equally treated rather than our national court. So anyone can appear. So all counsel who participate in this meeting, they should know that even if you have been admitted, as long as you can appear in the highest court of the national court, then you can be a counsel before the Eastern Court of Justice. So Article 37 of the treaty provide that manner of appearance. So you can appear as a counsel before the EAC. So you don't need to be a senior to appear before the court. And the other issues that have been discussed. Normally, what we are doing is in different countries there are a lot of laws passed by the government. So you have to cross-check with the making of the law process. To my experience, we've been taken cases before the Eastern Court of Justice. Most of them from the challenges of the laws enacted by the parliament in Tanzania. So in every year there are new laws enacted, and if you read between the lines, you find that most of the laws they are not compliant with the Eastern countries. So what you do is just to be on time, to follow the law process. Once it's become the law, once it's been signed by the president, then you take the matter before East African Court of Justice. If you see that there are some provisions which are in violation of the treaty, we did so before in the Media Services Act in Tanzania. We've challenged it. We filed a case challenging amendment of Political Parties Act. We've challenged the amendment of NGO Act, and a lot of laws in Tanzania. So whenever there is enactment of laws and you find that these laws are in violation of the treaty, so whether you are working with the different NGOs, example, personally I've been working with the different NGOs, with the Bar Association, with the East African Law Society, with the Pan-African Lawyers Union, Tanganyika Law Society, and the other NGOs. So most of the NGO will be interested to challenge these matters in court. So wherever you give advice to NGO and to other activists, so you have to think about, not necessarily to think about in your national courts. You have to think outside your national court, that the East African Court of Justice. Because we've been told the 60 days rules. on which you have to consider the issue of timing. So whenever there is enactment of the laws, you have to read the law in one side, then you put the treaty on the other side. As I've explained before, we've done so with the Media Services Act in Tanzania, on which we put one side the Media Services Act of Tanzania, and the other side you put the treaty. Then you compare whether this provision of the law is in line with the treaty. You know the principles of the treaty, the good governance, rule of law. So if you find that there is a provision which does not comply with the principle of good governance or democracy, rule of law, then you can approach the court on that side. That's one of the techniques have been used to challenge laws, to take the government to court. And what the court did is just to waive, to see the law and to see the treaty, whether it's in line or not. Apart from challenging the law, some of the cases we challenge the policy or the action of the government. Example, one of the cases we filed before the Eastern Court of Justice, we are challenging the action of the government to evict the Maasai community in their land. That case is still pending before the Eastern Court of Justice. We filed the case before the Eastern Court of Justice. We filed the application for injunction. We are successful in injunction. We go before the first instance division. We litigate the case before the first instance division. Somehow we lose the case. We go to the appellate division. The appellate division say that there was a mistake at the first instance division. So we are waiting for retrial of the case. So that's also another way on how we can approach the court. Not necessarily the law, but also you can approach the court by taking the matter, by taking the action of the government. What you need is just to consider the timing, the 60 days rule. So sometimes in the statutes, it's easy because you see the publication day, then you start to count the days from the publication day. But from the actions, you see if you are challenging the statement by the minister or the statement by the president or the policy, you look for the day it was announced or it was published in the government gazette or in the newspaper or somewhere. So you have to plead the 60 days rule. So it's so important to know that you are in time. And sometimes we are filing these cases because the 60 days rule, sometimes it may be very tight. So it's very important that you file on time. So sometimes you may file the application, which is not the 100% correct, or sometimes you lack some evidence. So sometimes we file it, then later on you may look for the amendment of the laws, or the amendment of your pleadings, so that you include the things which you left out when you are filing because you are rushing with the time. Or you may seek to file the additional evidence or additional affidavit so that you can cover with the time limit. But it's so important to consider the timing of the matter. So that's the key. So it's not necessarily that you have to challenge the law, but you also may challenge the action. And the action includes anything. It might be a criminal matter, it might be anything. But what you need is to equip with the principles of the treaty. And some of the cases we are filing in court, they are looking like they are pure human rights cases. But as long as you link with the treaty, then it's okay, and you can proceed with the matter. I give you an example of the Media Services Act, on which we are challenging the freedom of expression, the law which has been enacted by the Tanzania government, which we find that it's in violation of the treaty by violating some principles of journalism, freedom of expression, and so on. So we link that to freedom of expression at the cornerstone of democratic principles. As long as the treaty provides that democracy is among of the principles of the treaty, then anything which is against the democratic principle, the court can accept it and find that it has jurisdiction. Even the case which I was trying to explain, the case which we are challenging the action of the government, we evicted the Maasai community in their land, or also Sokwane Village Council and others. The other way you see it, you can find it's like a pure land case. It's like a land matter. But as long as we line it with the treaty, then the court finds that it has jurisdiction. Those are some of the issues which I wanted to express. Some of the things which I can say is that apart from framing that issues in that way, but you can still approach the court the other ways. So you may get the client which has interest in the matter, which has already been filed by the other party. So it may be filed by the Kenyan NGO, but you have interest from Tanzania. So you may apply to join as interested party. So the rules also allow to file as interested party. But also, you might find that there is a matter which has been filed by another country or another particular person or NGO, but you find that you have an expert on that matter, and you have interest in that matter, but you need to fight them to appear as amicus or as a friend of the court. That's also allowed. So you may represent a client who wanted to appear before the EACJ as amicus. So even that matter, even that way, you can still represent a client before the EACJ. So it's not necessarily you represent the applicant. You can represent the applicant. You can represent the interested party. You can represent the applicant, interested party, or amicus. So all those things are ways to approach the court. But also, we have been discussed about the res judicata principle. Sometimes, or most of the time, whenever there is a breach or there is any misconduct by the government, just know that the EACJ will have jurisdiction, but also the National Court will have jurisdiction. I give you an example of those cases: the Media Services Act case, the land eviction case. You can still find a land matter, but also a parallel you can find before the East African Court of Justice. In one of the cases, we filed the same matter, that the Media Council of Tanzania, and the others, there's the United Republic of Tanzania. We meet with that preliminary objection, because at the same time, we also filed another similar matter, different parties, but it was in High Court of Tanzania in Mwanza region. And the court, the respondent raised the said preliminary objection. After raising the said preliminary objection, the court interpreted and said that no, the matter before us is just to interpret the treaty. We are not dealing with the constitutionality of the matter. We are dealing whether this particular law comply with the treaty. So those are some of the key ways on how to approach the court. But also, we've been told that there are in a number of cases, the court has already indirectly declared that it has human rights jurisdiction. Though it's still debatable, but if you have a human rights matter, you approach the court by pegging that matter on the principles of the treaty. And to another thing which I want to mention is the EACJ might have jurisdiction if we have in commercial matter, if there is a clause in the agreement. So when we advise our clients, when we draft our commercial contracts, we have to remember when we are thinking about the arbitration clause, we remember that the East African Court of Justice has that mandate if the parties decided to give that mandate to the court. So I advise most of the people try to advise your clients that whenever you're drafting your commercial contract, investment contract, remember that you may have arbitration clause before the EACJ. That's according to Article 32 of the treaty. Those are among the issues which I want to discuss, because I find that time is not in our favor. Maybe we should listen to the questions before I proceed, unless the moderator says that I can proceed. Thank you.
Thank you. Thank you very much. And indeed, we have a lot of questions. I don't know that we shall be able to go through all of them because of time, But briefly, I'd want to encourage our listeners and colleagues in the profession to please stay with us for a few more minutes to allow us to go through the questions. And I promise we will not take more than 10 minutes. I'm going to go through all the questions, and I'll invite the keynote speaker or our panelists to address some of the questions. So we have Luke Emmanuel, who says, I'm an advocate from South Sudan. I would like to ask a question on the procedural filing requirements since I arrived late. I think that will go to the keynote speaker. Your Worship, thank you for your insightful submission. As we're in a critical period of election in Kenya and Uganda, in Tanzania and Uganda, heading to the polls, it's important to reflect on the role of the EACJ in addressing electoral disputes that may violate the EAC treaty. We have seen cases like the Martha Karua matter. Many such disputes have ended up before the court. However, as your submission and past judgments indicate, the question of jurisdiction remains unsettled. In light of this, what measures can be taken to strengthen the court's mandate to better promote and safeguard electoral justice in the region? So we have a question from Winston, who says, how do you enforce the court orders against member states? I think I will let the keynote speaker address those three questions. And then what specific mechanisms can, such as arbitration or mediation, does the EACJ promote or facilitate for the out-of-court resolution of cross-border trade and investment disputes within the community, and how can parties access them? That question, I'll give it to Jebra, because you've talked about arbitration. And then Eric Kambale, for sure, our panelist, is giving a library of the EACJ. I thank him for good information he gave us, but I have one question. Language is a really challenger to access to justice in the EACJ for French citizens. How can we cover that? Please, our keynote speaker, Your Worship, please address that question. Damas says, my question goes to Emily. Emily, could you elaborate more with regard to circumstances under which illegally obtained evidence is admissible? In the mentioned case versus AG of Tanzania. Emily, please elaborate on that. And then what specific mechanisms, such as arbitration or mediation, does the EACJ promote? I think we have a question on arbitration prior, so I will let Jebra handle that. Chair, I joined late. Could you please share the agenda? Oh, I'm really sorry, I'm just seeing this. But maybe what I'll share the presentations. I'll request the Secretary to share the presentations to all the attendees. What's the really strategy can a lawyer use to avoid problems of time limitation at the EACJ? Emily, I'll let you say something small slightly on that. And what about enforcement of EACJ to national courts? Jebra mentioned Media Council versus AG case. In this, Media Council was challenging the Media Service Act of 2016, which violates the treaty. The case was decided in favor of Media Council, that the Media Service Act should be amended. But until today, the law hasn't been changed. It seems there is lack of enforcement. Jebra, can you please highlight on that? Jebra mentioned res judicata. Now my question is, what about res sub judice? Jebra, again, that's for you. And then, Your Worship, thank you for your insightful submission. Okay, that has been covered. Emily, can I get your email or telephone contact for some drafts? Emily, please share your email, if you don't mind, in the inbox, in the chat group. My question is to Emily. She said only residents can swear affidavits. How about expert evidence affidavits from outside the EAC? So all our speakers, we have 2 minutes each to answer the questions. I'm going to start with Your Worship. Please come and address the questions.
Yeah, okay, thank you. Let me start with the last one, which is the issue of the language, French speakers. Look at that problem historically, that when EAC started, it had only 3 members, and all of them were Anglophones and Kiswahili speakers. So the French came in much later, and even when Rwanda and Burundi joined, they had to just switch to English. It's only the last 5 years or so that the summit approved French to be an official language of EAC with Kiswahili. Of course, there was a lot of debate on that. Fine, the summit took a decision, but the instruments have not been changed. And you know, the court goes by the rules. The treaty still says the language of the court is English, in as much as the summit decided that even French is the official language of the community. So until that is done, I'm afraid French speakers may continue having issues until the treaty is amended to include those languages, because this is the court and it operates. If you want to do anything, change the law and it will follow. That is one. How do we impose court orders on member states? This question, I think, talks to implementation of decisions of the EACJ decisions. And as I said, EACJ made it very easy. If you want to implement a decision of its decision, just use the local mechanism that are applicable in your country. The same way you execute against the government in your country is the same way. Now, here what happens is that you take that court order or the decision of EACJ, append it to the letter of the registrar, and then come and file it at your national court. Now, your national courts adapts it as if it is a judgment issued by it. And then the normal execution procedures under the Civil Procedure Act will take place. That should not be a problem. If EACJ has mandate over electoral justice, I will say limited mandate. For example, EACJ has no mandate in election petitions where you want to overturn a decision of an election result. That is a preserve of the election court of the national court. But EACJ has a limited jurisdiction here in that if in those elections there was some violations of the treaty, and that's what happened in the case of Matakakwa, then EACJ can come in and declare that those actions that happened during elections were a violation of the treaty. But it will not go ahead and say, because it was a violation of the treaty, we are therefore overturning the election of so and so, because EACJ is not, it cannot be a returning officer for those elections. I hope I've covered them precisely and to the point. Thank you.
Thank you very much, Your Worship. Yes, you have indeed covered them ably. And now let's have Emily. Emily, can you please join in and answer your questions?
Thank you. Let me start with the question on expert witness. Now, let me clarify clearly that if the suit is filed by individual or legal person, there is a requirement of residence. That legal or individual person has to ensure that the affidavit is deposed in Kenya or in any of the partner states in Uganda or Rwanda, Burundi, any of the partner states of the EAC. Now, because the expert witness is coming to support the applicant, in my view, and how I view it is that there will be a case like sort of challenging the illegalities of committed by a partner state. Therefore, how I view it is that it's good to be, when you're drafting your pleadings, you just be smart, ensure that expert witness depends in any of this. Maybe during the time they travel, or you can just depend any of the places within the partner state. But for other references that are not for legal and individual person, the issue of residence does not arise. And even the issue of 30 days, 60 days or timeline does not arise. I just wanted to clarify that clearly. The 60 days will arise if it's a legal and individual person filing a suit at the EACJ. The issue of residence also arises if the case is filed by a legal and individual person. So ensure all the affidavits are deposed within a partner state if the suit is filed by a legal or an individual person against the government. Now, on the issue of illegally obtained evidence, in the case of Anthony Kalist Komu versus United Republic of Tanzania, Anthony Kalist Komu obtained evidence from Tanzania in a manner that he could not disclose. He used shortcuts because, you know, sometimes getting evidence from the government is very difficult. Following the process, you have to request for information from the government. Sometimes you cannot be given. So he used the shortcuts, obtain that evidence. Now, what the court said, as long as that evidence was not being, it was admitted by the other side. They did not challenge it. They also relied on it. Therefore, the court said there's no need, in as much as it's been obtained by ways you cannot disclose, it's okay. Even another case is Attorney General of Uganda versus East Africa Law Society, and another in Appeal number 1 of 2013. In that case as well, evidence was obtained through wrong channels, because sometimes getting evidence from government is very difficult. And I'm sure that's why the EACJ is alive to that fact. And in that case, what happened was that in as much as that happened, the other parties relied on the evidence, and the court was that evidence is admissible. So that is one route, but sometimes to avoid that challenge is you can file for discovery of evidence. If the evidence is with the government and you have a suit and you need some information, you can make an application before the court that they issue information. But if you can use shortcuts to get the information, it's still okay, as long as the other side will rely on it. And I know even in the case of trade that we handled, we had to use some ways to get some information from the government. But the good thing, they didn't challenge and say, oh, how did you get this kind of information? They were okay with that information. The last question is, Mabel, could you remind me the last question? I think I've exhausted
so the last question, there was a question requesting you to share your email.
Yes, I did share. Yeah, I think I've exhausted. Thank you.
Okay, that's it. Can we, thank you so much, Emily. Lastly, can we have Jebra kindly answer your questions, please, in 1 or 2 minutes?
Thank you so much. What I want to say about arbitration and mediation before the East African Court of Justice. First, the arbitration mandate of the court is upon the parties decide to give the power to the court to decide. So there are rules of arbitration before the EACJ when they decide to adopt it, and there are a number of ways which you find that the judges have been trained to conduct mediation before EACJ. And apart from that, even Emilio was talking about first PTC pre-trial conference. I mean, first PTC is common in Tanzania, pre-trial conference. So this pre-trial conference, they try to facilitate mediation. So you still have the chance to mediate. So the court is trying to be friendly to the respondents and the parties. If you are willing to mediate, then the court can conduct mediation. On the issue of enforcement, enforcement has been a challenge, not necessarily in international courts, but also even the local court decisions. So the only way, as former registrar tried to explain, you need to file, especially it's easy when it's in form of monetary way, on which you can file in your national court and execute as the decision of the national court. But though when the decision for declaratory orders, it is still a challenge. So there are a number of ways we try to improve. Example, there are some ways we find some of the cases are still pending in court, on which you try to take back the case to court so that the court can find the contempt against the respondent to see how we can enforce this decision. So there are some cases which are still pending in court, which are in form of contempt. On the issue of res judicata, the same applies as res sub judice. So even res sub judice does not apply, because these are two different causes of action before national court and before Eastern Court of Justice. And I want to say a particular thing about it. On expert evidence, you can take an evidence to an expert, not necessarily to be a party to a national state. There are some cases on which we try to find it. We find an expert evidence. The case was between Tanzania, the one I will mention about the Masai or Sokwani case. One of the evidence we try to take evidence from experts from Kenya, and that the case on which the court said that we filed expert evidence, but we did not provide a passport to prove that this guy actually crossed it from Kenya to Tanzania. But The appellate division said that no, that was too much. The first instance division was supposed to consider the content of evidence, the content of expert evidence, not necessarily to look for the whether he has crossed to Tanzania or not. So you can take, Emil was talking about the, if you say an affidavit from Dar es Salaam, it has to be from Dar es Salaam, or from Nairobi, or from Uganda. So it can be from a member of the resident state, but an expert opinion, expert evidence, you can take it anywhere because that's the international court. Thank you so much.
Wow, wow, wow. Thank you so much. I think we can all agree that this was a masterclass. This was a masterclass. And personally, I'm charged. I want to file a public interest litigation for our French members who are facing language issues at the EAC. So allow me to extend my deepest gratitude to all of you for your active participation and engagement. A special thanks to our keynote speaker, your worship, and our panelists, our distinguished practitioners for sharing their expertise and practical insights in navigating the EACJ. You have given us litigation strategies and various insights in navigating EACJ practice. And you have made today's discussion rich, thought-provoking, and I think we can all agree that this conversation is very relevant in the evolving landscape of regional dispute resolution. So thank you very much. We also want to thank the organizing team at the East African Law Society. Gabriel and your team, thank you so much for making this webinar possible. And most importantly, our participants from all the 8 East African countries, thank you so much. We had, I think, over 180 attendees today. Thank you so much for taking time to join us, ask questions, and we believe that all our shared perspectives are key to strengthening our professional community. And we look forward to staying connected, especially us from the Committee of Regional Integration and International Trade would want to stay connected. We want to build lessons that we've learned today, and would want to meet again in future sessions to discuss more topics and issues relating to regional trade and integration and international trade in general. So thank you once again, and we wish you all the best in your practice and professional journey, and have a wonderful evening, everyone. Thank you, thank you, thank you. Thank you for joining us.